Welcome and good afternoon, everybody. My name is Gokul Plaha, and I am a consultant with the CUTS Institute for Regulation and Competition, or CIRC. I am privileged and honored to have an academic of Dr. Stavros Makris' eminence as our guest speaker for today's webinar titled Commitment Decisions in the Era of Ex-ante Platform Regulations. Amongst the audience, we have distinguished competition law and policy experts, antitrust lawyers, antitrust enthusiasts, and students. I want to take a moment to personally thank each and every participant for showing up to this discussion. The CIRC strives to be at the forefront of exploring regulatory and policy issues relating to the fields of law, economics, and public policy. Let me now introduce Dr. Stavros Makris. Dr. Makris joined the University of Glasgow as a lecturer in competition law in September 2022. He previously taught EU competition law and US antitrust at London School of Economics and Political Science Law School, and various law courses at Wageningen University in Netherlands and Sciences Po in Paris. Dr. Stavros holds a Bachelor of Law and a Master's in Philosophy of Law with distinction from the University of Athens Law School and an LLM from University College London Law School. Stavros completed his PhD in competition law at the European University Institute. His thesis develops the idea of EU competition law as responsive law and explores the European Commission's commitments practice under this lens. During his doctoral studies, he was an editor and the EU law head of section of the European Journal Legal Studies, the coordinator of EUI Competition Law Working Group, and a gracious visiting researcher at the University of Michigan Law School. He has served as an expert advisor for the Hellenic Competition Commission and as a peer reviewer for several leading competition law journals like Journal of Antitrust Enforcement and Journal of Competition Law and Economics. Dr. Makris' research revolves around three key themes: competition law, digital technologies, and sustainability. His research focuses on how competition law can incorporate new knowledge and remain adaptive to changing societal circumstances without losing its integrity, as well as on how competition law and regulation can be used to bring digital markets in line with a competitive, fair, and sustainable economy. He is particularly keen to work on projects concerning the philosophical foundations of competition law and the challenges of digital and greener economy, antitrust, and digital markets issues. Dr. Stavros has worked on a book with Cambridge University Press titled Responsive Antitrust, an Inquiry into European Commission's Commitment Practice. And he has also worked on a collective volume with, again, Cambridge University Press titled Handbook on the Theoretical Foundations of Competition Law, Interdisciplinary Approaches to Rethinking Competition Law. Here's where I would want to turn the audience's attention to the law and policy context for this colloquy. Today, competition law and policy find themselves at a crossroads. Arguably, the new consensus in antitrust academia across the world is that traditional competition law enforcement doesn't adequately capture, much less remedy, the novel harms emanating from the digital economy. That's because the economics of digital markets is markedly different from the economics of traditional markets. In a report titled Anti-Competitive Practices by Big Tech Companies, the Standing Committee on Finance of India's lower house of parliament states that digital markets are characterized by, quote, massively powerful increasing return to size economies. Those increasing returns, the report goes on to state, quote, result not just from traditional scale and scope effects, but also dramatically powerful learning and network effects. As a consequence, digital markets lack the kind of fairness and contestability one can find in traditional markets. Some of the ostensibly, and I stress the word ostensibly here, novel harms flowing from these peculiar market dynamics are killer acquisitions, anti-steering provisions, algorithmic self-preferencing, anti-competitive data-related practices, search bias, etc. Not just India, but jurisdictions around the world are deliberating whether antitrust law in the digital realm needs a complete overhaul. Germany and the European Union have devised ex-ante legislations that place multiple restrictions, requirements, and obligations on the conduct of digital behemoths. And Britain has come up with a draft bill along similar lines. Against this backdrop, Questions arise about the role and effectiveness of commitments and settlements as an enforcement mechanism. A traditional ex post tool in the regulatory arsenal, interestingly, commitment decisions also find a place in ex ante regulatory regimes. For example, Article 25 of the DMA empowers the European Commission to adopt binding commitments with respect to obligations laid down in Articles 5, 6, and 7. Dr. Macris will discuss the role traditional commitment and settlement decisions can play at a time when jurisdictions around the world are contemplating similar regulatory initiatives. He will also discuss whether ex post commitments can support ex ante regulation to bolster fairness and contestability in digital markets. Finally, Dr. Macris will discuss whether ex ante commitments and settlements can tackle problems related to fairness and contestability alone. Dr. Macris, I must add, is a globally renowned expert on both ex ante regulation and ex post commitments and settlements. The audience is sure to benefit immensely from today's presentation and discussion. Very few in the world can share the knowledge, insights, perspectives, and analysis that Dr. Macris will share today. He will hold the floor for 20 minutes. After that, he will engage in a free-flowing discussion with the audience. Over to you, Dr. Macris.
Thanks a lot, Gokul, for this very kind introduction. So let me just share my slides. Okay, so good morning, everyone. It's a pleasure and a privilege to be with you virtually at some point. Hopefully, I will also meet you in person. So in my 20 minutes, as Gokul mentioned, I will be talking about commitment decisions in the era of ex-ante regulation. And one of the main points I will be making is that commitments, if used properly, can be a particularly useful tool in that context. So before delving into commitments, let me just say a few words about the other part of the title, the era of ex-ante regulations and what brought us here. So as we all know, or perhaps suspect, digital markets have served as a game changer. This is because of certain features of digital markets. Digital markets demonstrate extreme returns to scale and network effects, and these two elements have led to the rise of digital platforms, multi-sided platforms, which provide actually the terrain where different clusters of users interact. So in a way, digital platforms replace actual markets, and eventually, we have been witnessing the transition from platforms as neutral intermediaries to digital ecosystems. So these digital ecosystems operate as agglomerations or as gatekeepers, and they control and they orchestrate the whole value chain. And what is particularly useful or particularly interesting from a competition law perspective is that these digital ecosystems have on their hands cloud capital, big data, and AI, and these kind of tools have given rise to tremendous efficiencies, but also have given rise to opportunities for anti-competitive practices. And in this setting, somehow competition law is perplexed, has demonstrated some inertia or its limitations. And this is particularly because of its case-by-case mode of analysis. So in competition law, we have to litigate every case. We have to define the relevant market, demonstrate market power, especially when it comes to abuse of dominance. And then we have to establish actual or potential anti-competitive effects. These kind of elements are particularly difficult to establish in digital markets. And to add to that, digital markets might require a refinement or a reconceptualization of these elements. On top of this, there are several digital competition cases where the remedial response given by competition authorities or courts has proven to be inadequate. Add to this the lengthy and cumbersome procedures that are associated with competition law enforcement, and then we see why several jurisdictions have come up with ex-ante regulations. The ex-ante regulations we are witnessing in different jurisdictions are actually pursuing slightly different objectives from competition law's objectives, and perhaps we'll come back to that in the discussion. For instance, the DMA seeks to promote openness and contestability, fairness and contestability in digital markets. but most of the provisions of the DMA are competition law inspired. And also, in tandem, we see a turn towards more flexible enforcement tools, and one of them is commitments. And the expectation is that in the future, we'll be seeing more and more of this combination of ex-ante regulatory obligations and more flexible tools. And when I say more flexible tools, I compare commitments to the standard, traditional, conventional enforcement procedure of infringement decisions, where the authority investigates a violation, articulates a theory of harm, collects all the evidence, and imposes a fine. So in the DMA, in Article 25, commitments feature prominently, and and what is stipulated there is that the gatekeeper, when they are in the process of a market investigation for systematic non-compliance by the Commission, they can offer commitments voluntarily in order to alleviate the Commission's concern and close the investigation. And the Commission can reopen the investigation if there is a material change, or if the gatekeeper acts contrary to the commitment, or if the commitments were relied upon information that was incomplete, incorrect, or misleading. And it's important to notice here that this article, Article 25, that will be tested in the following months, draws its inspiration from Article 9 of Regulation 1, the traditional commitment decisions. So I have here the text of the article for you to compare. So in a very similar line as Article 25, Article 9 of Regulation 1 stipulates that in the course of an investigation, after they receive, for instance, a preliminary assessment, the undertakings, the companies, they can propose to the Commission to close the case by adopting certain remedies, proposed commitments. The Commission will market test these commitments, which means that it will invite third parties to consider whether the proposed remedies deal effectively with the identified competition problem. And if that's the case, the Commission will declare the commitments legally binding. The undertaking, the companies will have to modify their behavior and to respect this document. What is important to notice here is that commitments do not include any formal finding of an infringement. They do not include a fully articulated theory of harm, and also they do not rely on a full-fledged investigation. And as you see in the second paragraph of Article 9, again, in a similar fashion as under Article 25, the Commission can reopen the proceedings if there is a material change in any of the facts of the case, if the undertaking acts contrary to the commitments, or if the commitments were relied upon information that is incomplete, incorrect, or misleading. Another thing that is worth mentioning is that if commitments are violated, so if committed undertakings decide to deviate from what they promised, then the Commission can impose a fine up to 10% of the total turnover of the undertakings without establishing any additional infringement. And also it can impose periodic penalties to ensure compliance. Excuse me. So now, let me just highlight some of the key features of this enforcement mechanism that, as already made clear, deviates from the traditional conventional enforcement path. So commitments do not include a formal finding on infringement, but they are legally binding. Also, there is a general principle in Regulation 1, 2003, according to which commitments are not appropriate for hardcore antitrust violations, such as secret cartels. Another important element of commitments is the market test stage. In this stage, the information, the third parties test the appropriateness of commitments. So the Commission has the opportunity to get information about the market or about the practice from rivals. And usually, the practice has shown that market testing leads to modifications in commitments. Two additional points should be made here. The first is that through this process of negotiation, bilateral and tripartite negotiation, commitments usually amount to tailor-made remedies, negotiated solutions that propose a particular fix to a specific problem. This is the general structure of commitments. And also, commitments, because of their settlement element, they are subjected to a light-weighted judicial review. And let me elaborate a little bit on that. So the court in Alrosa recognized that commitments differ from infringement decisions because they are negotiated, because they are offered voluntarily. So the court said in this case that the undertakings, the companies that offer commitments, they also accept that the remedies that can be imposed on them via commitments can go beyond what can be imposed on them via the traditional infringement procedure. Therefore, the principle of proportionality applies on commitments, but in a narrower fashion, which means that the Commission is only obliged to examine whether the measures, the remedies proposed by the committing undertakings are the less onerous ones that appropriately, adequately tackle its concerns. It doesn't have to find the most appropriate solution. It only has to establish that among the several proposals that the undertakings made, the adopted ones are the less onerous ones, but the ones that address the problem. And now let me turn to the remedies, the remedial solutions that have been adopted via remedies. And there we see a wide range of different behavioral and structural remedies. So the Commission has used commitments to modify standard terms and conditions in the contracts of the companies involved, to compel them to divest assets or to invest further in capacity. We saw that in commitments in the energy sector, and these commitments were quite intrusive, if I may say. Also, commitments have been used to devise more innovative remedies. I will get back to that soon, but one indicative case is the Microsoft one. And also commitments have been used even to articulate, to impose provisional price controls. I will get back to that with an example shortly. So let me now give you two examples of commitment decisions. So in the Aspen case, the Commission was worried that the prices charged by Aspen on 6 life-saving anti-cancer drugs were excessive. The company was also engaging in a handful of other practices that raised suspicion. So, for instance, the threat of delisting and withdrawing the drugs, or they engage in strategic sequencing of their price increases. So the Commission made a case, and the case revolved around abuse of dominance. The main point was that the prices charged by Aspen over these 6 drugs were excessive and unfair, and on this basis, abusive. The Commission then, in order to establish that, observed the price increases, and it found out that these price increases significantly exceeded the median of a particular formula that included the costs of the drugs, a plus element, so a reasonable expectation of profit, and the Commission compared this price with the actual price, and it found out that the actual price on average was between 280 and 300% more than the cost plus formula. On this basis, the Commission established the excessiveness. And on top of that, the Commission asked whether the prices are unfair in themselves, the second limb of the test. And there it asked whether there are any legitimate reasons that could justify these very high markups. In their absence, the Commission established the abuse. the outcome of the case was, and I established here inaccurately, because the commission used these elements and it made its case and it proposed to Aspen that they might have violated Article 102. In light of this evidence, Aspen, and without finding any infringement, right, Aspen agreed to reduce remarkably, on average by 73%, the prices of its 6 drugs. And that was the content of the commitments in that case, the price decrease, which was provisional, as you can see here. That's why I said commitments can even go as further as to establish provisional price controls. Another case is the Microsoft commitments. In this case, the Commission was worried that Microsoft had tied its web browser with the Windows operating system, and by engaging in this practice, it's abused its dominant position in the operating systems, and it foreclosed access to competing developers. Again, this was the allegation, this was the concern. In order to close the case, company, Microsoft, proposed a remedy, and the remedy was a choice screen, which would be available to all users of Windows. And this choice screen would allow them to choose other competing web browsers. And also, these commitments had a duration of 5 years. So the Commission was happy with this remedy because it would instigate more choice in the web browser market and also facilitate innovation. And on these grounds, it closed the case. In 2012, it found out that the company, that Microsoft, failed to comply with its commitments. It didn't display the choice screen, and users were deprived of this option. And also, it established that the deviation, the violation of commitments lasted for 14 months, and it affected more than 15 million users. On this basis, it imposed a fine of 561 million, which, even though it might sound pretty large, it amounts only to 1% of the annual turnover of the company. So now that we saw 2 examples, we already suspect that there are certain reasons why companies and enforcers might opt for commitments. For instance, when it comes to companies, it's pretty obvious that commitments offer a good shelter to close a case rapidly. They increase certainty because if you think as a company, right, you have more control over the procedure. You can negotiate the remedies, so you have also control over the adopted solutions. And also you avoid the fine and the reputational damage that is associated with an infringement decision. On top of that, you avoid further judicial scrutiny over your behavior, and you discourage follow-on private litigation. Without an infringement decision, it's particularly difficult for individuals, consumers, for instance, other rivals, to sue the company because the available evidence might not be there. The necessary evidence might not be there. So these are the reasons for companies to commit, but there are also certain benefits for the authorities. So the authorities ensure quick, rapid resolution, so procedural economy. They can also close weak cases, and they can prioritize their enforcement activities in a better fashion, perhaps. Also, they can use more, they have more discretion when it comes to behavioral and structural remedies. Remember, I mentioned Alrosa, and Alrosa imposed a rather light-weighted standard of review. Therefore, the authorities have more leeway to experiment with different remedies. Also, commitments might allow the authorities to deal with information asymmetries. How? Through the market testing procedure. So there is this additional stage in the commitment procedure where third parties are invited to raise their concerns. Therefore, the Commission gets information about the sector, information that it wouldn't be able to gather in the absence of such a procedure. And also the Commission might be satisfied that through this process, it identifies tailor-made solutions. Especially in digital markets, for the reasons we mentioned in the beginning, a simple fine, no matter how high it is, it might not solve the problem. It might not change the market dynamics. So perhaps tailor-made solutions, particular remedies, might do more good in this context. And also, via commitments, the Commission can impose monitoring or implementation structures. For instance, it can appoint a monitoring trustee to see whether the company respected the adopted remedies. So there are several reasons to commit, but there are certain also pitfalls in this procedure. So what can go wrong in commitments? One key element is that during commitments, the parties, both the Commission and the undertakings, the companies, bargain in the shadow of law. As a result, they avoid effective judicial review. This means that commitments can lead to over-enforcement or under-enforcement. They can also even lead to regulatory or intellectual capture because the third party control, the judicial control of this negotiation is rather limited. Simultaneously, if commitments are used for novel and complex practices, judges are precluded from developing the law. So we might be deprived of having a clear statement on what is wrong, what is the theory of harm in a particular case. Also, commitments, because of the discretion they give, they might allow for instrumentalization. The enforcers might use commitments for purposes that are remotely connected with the purpose at hand, be that the protection of effective competition in Article 9 or the promotion of contestability and fairness in digital markets under Article 25 of the DMA. And also, commitments might have a major impact on third parties, but the third parties, remember, they participate only in the market testing of the commitment. So commitments might compel the company, the committing company, to change its contracts, but the third parties that are affected by this contractual modification are only, they had only the opportunity to raise their concerns in the market testing procedure. So it might have some repercussions there. And let me now close with a few points on how we can address these concerns, and then let's open the floor to discuss. I'm really eager to hear your questions and comments. So a way to put some order in the use of commitments is to see them as a part of a pyramid of responsive enforcement. What I mean by that is that enforcers should realize that they have at their disposal a whole pyramid, a wide array of different enforcement tools that are softer or harder. Let's say that infringement decisions are the hardest because you can impose a fine, you can even impose behavioral structural remedies, and then there are tools of reduced, let's say, intrusiveness. Even though commitments have not always been used in that way, even though commitments have been used in certain cases in a rather intrusive manner, this kind of pyramid can distill more rationale to their use. So if enforcers realize that they have several tools and they should orchestrate their enforcement strategy and tactics in a coherent way, then they can identify what is the precise role of commitments. And let me give you an example. For instance, there is a novel case or there is a sector that is of particular importance and complexity. So maybe there, the best way to intervene is to conduct a sector investigation and issue certain guidelines. Then the enforcers, they can use letters of inapplicability or letters of comfort in order to provide some certainty to the companies involved. The third step could be commitments, so imposing certain remedies and modifications on their on the company's behavior. And only if this doesn't work, then the enforcers should proceed with the more fearful, the more intrusive big guns such as interim measures or infringement decisions. So this will entail that the enforcement, the enforcement of authorities will be rational, will be coherent, will be measured in a way, but also that the authorities will not be victims of regulatory capture or regulatory gaming, as long as they use commitments, but they are inclined also to use more intrusive, harder enforcement mechanisms, such infringement decisions. Okay, let me stop here. And I hope I was in time and we'll have some time for discussion.
Thank you, Dr. Macris, for what was an excellent, very insightful, and a very concise presentation. I'm sure the audience members got a lot of learning from it. We will now open the floor for questions. Please go ahead and ask Dr. Macris your questions. Questions?
I encourage all people to come forward and ask questions, please. But in the meantime, Dr. Macris, I would be very keen to understand from you, based on your exhaustive study of, I don't know how many dozen or 100 commitment decisions, if you can distill them in some of the design principles, because it's a process, right? It's a process which involves essentially negotiation between two parties. There is a party which is offering commitments. There's a party which is accepting commitments. So therefore, the offering party would endeavor to offer minimum. The accepting party would seek to extract maximum. So they are both pursuing opposite or conflicting goals. Right? And so therefore, how to design this process in a manner that there is a balance. And in this process, we not only see the real problems getting addressed in time, but also without really misusing this legal provision, which you highlighted in some of the later slides. One is interested to understand this whole process from a legal design perspective. How to design this? I mean, a competition authority, how can it lay down the process in a manner that it becomes transparent, objective, and fair at every step? And how can it become more acceptable, more, can encourage more private parties to participate in this? So your design perspective on this, over to you.
That's a fantastic question, Navneet. Let me cut to the chase immediately. So first of all, when it comes to commitments, we have two tiers of discretion. The first tier discretion is between commitments or other instruments, infringement decisions, other type of settlements, letters of inapplicability, etc., etc. And the second tier has to do with the design of remedies. So these are the two main points in the procedure where the authority has to make an essential choice, right? So when it comes to the exercise of the first tier discretion, and I have written on that, different systems follow different solutions. So for instance, Germany and France and UK, they have issued guidelines that they identify the criteria under which they should, as authorities, right, go for commitments, and the criteria under which they should abstain from using commitments and go immediately to the benign big guns of infringement decisions. As I mentioned in recital 13 of Regulation 1, the regulation states that commitments are not appropriate when it comes to secret cartels or hardcore violations. This means that when we have something that is so problematic for competition, that we need to punish the undertaker, or also we need to enhance the deterrent effect of the law, commitments are not the most appropriate instrument. Also, on the other hand, if something is a mild violation and the fix is easily identifiable, then it's better to solve the case via commitments. Also, commitments can be used after we have a pilot case. So after we have a pilot case that settles the issue, the Commission can use commitments for other similar violations, right? Because it doesn't need to retest the theory of harm, and it doesn't need to retest the remedy. So after we have a pilot case that is tested and a remedy that is proven right, then we can go for commitments. Also, commitments, in my view, are not really appropriate when we have a particularly novel theory of harm. Why is that? Because commitments contain, as I mentioned, a rather sketchy theory of harm. So it is better to test this kind of theory of harm before the courts and have a clear statement about its merits instead of settling the case quickly. And I'm saying that because even though commitments, also in the EU, right, they were designed with these kind of principles in mind, of course, enforcers are always, let's say, victims of the circumstances, and they have to make practical decisions on practical matters. So we have been seeing uses of commitments that are incoherent. For instance, using commitments against practices, collusive practices that are similar, very similar to cartels. This is a no-go for if you ask me. Also, using commitments to settle complex cases. This perpetuates the uncertainty, perpetuates the lack of clarity. So one way to solve these issues would be to issue guidelines, as authorities have done in several jurisdictions, that explain where in advance where the Commission will accept commitments, under what criteria, deterrent effect, clarity, certainty, right? And under what criteria commitments are not appropriate. And then the second point, when it comes to the second tier discussion, the remedial design, this is rather hard to untangle. This is rather hard to settle in advance. But what can help there, as I mentioned, is to have a pilot case. So for instance, we have the Google shopping case, right? So we have the Google shopping case. This case was tested. The theory of harm was discussed, was debated before the courts. And now, for instance, the Commission can use commitments to impose self-preferencing on other companies, see the market, the Amazon marketplace investigation, without getting into the trouble of issuing an infringement decision. So this could be a way to deal with the remedial design problem. And let me just make a last comment on judicial review. So I think also the court is realizing that very light-weighted judicial review of commitments might be problematic, because even though commitments are a contract between enforcers and companies, third-party rights might be violated or ignored or disrespected. And also commitments might lead to over-enforcement or under-enforcement. The companies might feel very, very intimidated, or enforcers might just be hurried to close a case, right? So agree on underwhelming remedies. So judicial review, for me, a more intensified judicial review could be a check over this system. And I'll stop here.
Right, I would reiterate, if any of the participants have any questions. I can see the distinguished presence of Mr. Alan Asher and other colleagues here. Please feel free to tune in questions, unmute yourself, ask questions. But to ask a follow-up question of what I just asked, let's say you said that the third-party rights might get adversely impacted because they did not get an adequate opportunity to participate in that process. Is there a best practice to address that? I mean, in addition to seeking public comments, but is there anything else you have observed in your research which has worked to the advantage of relevant third parties, not irrelevant third parties?
In Canal Plus, in this case, the court addressed this issue, and the court found out that third parties' rights can be seriously harmed or affected by the commitment procedure. So, in this sense, it imposed an obligation on the Commission to really hear their concern. And also another thing that can be imposed, but it doesn't naturally deviate from this case law, is that the Commission has to reason why it doesn't accept or it denies certain concerns or certain proposals made by third parties. Also, the Commission might be compelled, the enforcer in general, right, might be compelled to conduct an analysis of how the commitments will impact on the legal and economic status of the third parties. But the start has already been made with Canal Plus, where the court recognized that even though the parties were not legally involved in the commitment procedure, because their economic status was affected, they had the right to say, they had the right to raise their concerns in the procedure, and their rights had to be taken into consideration. So I guess this could be ways to address the issue.
Right. And that's really illuminating. But in terms of I mean, I'm not sure if you have given us some examples of digital economy or tech companies offering commitments. But have you also noticed anything particular or significant after the passage of DMA?
It's too early to say, because with the DMA, first of all, in Article 10, it is made clear that the DMA has different objectives compared to competition law, right? So fairness and contestability. Also, recently, we saw the first designation decisions where gatekeepers are designated with regards to their core platform services. And this is the structure of the DMA. After that, the gatekeepers have to demonstrate their compliance. They have to demonstrate that they comply with the obligations of Article 5, 6, and 7, right? Interoperability requirements, duties to provide access to certain assets, not to engage in self-preferencing, not to use MFN and anti-steering clauses, stuff like that. So commitments in this framework haven't been used yet, because they will be used under the procedure of Article 18 in case of systematic non-compliance. And this actually can make the DMA future-proof. Why am I saying that? Let me give you an example. The obligation of the prohibition on self-preferencing, provided and enshrined in Article 6, right, is obviously inspired by the Google Shopping case. But in Google Shopping, we had a complex behavior, a composite behavior. Google was promoting its own comparison shopping services, and it was also demoting the rivals to the digital Siberia of page 4 and 5. And on this basis, the court said that Google abused this position because it engaged in unequal treatment or in abusive leveraging. The court did not use the term self-preference. But the DMA is inspired, obviously, by this case. So now that the self-preferencing obligation will be imposed across the board to several gatekeepers with regards to their core platform services, we might have problems, right? There might be uncertainty. And there was reasonable concern that the DMA is very heavy, is very rigid, it will be applied in a blatant way across the board, so it will be too much or too little, etc., etc. Now, with the market investigation procedure and the commitment procedure that is a negotiation, we have the opportunity, the Commission will have the opportunity to identify the needs and bolts, right? To identify how this self-preferencing obligation is to be applied in particular sectors, and it might also prioritize there, right? So this could be a way to use commitments. I suspect that this would be the way, and this will add flexibility to the DMA structure, something that seems, or according to some critics, is lacking. And if you just compare the DMA with the DMCC, so the ex-ante regulation that will be soon adopted in the UK, the DMCC has a very different structure, because in the DMCC, you have some principles, and then there will be bilateral negotiations between the CMA and the platforms with strategic status. So the critique there was that the DMCC is much more flexible than the DMA. But if the DMA that imposes ex-ante rigid obligations is recalibrated through the commitment procedure, it can also have an advantage in that regard, right? Because there are obligations, and then there is a procedure to negotiate and concretize these obligations. So it doesn't become too blatant.
Thank you. Any questions from the floor? Any questions, comments, observations? Yes, please.
Good evening, sir. This is Rashmi Rai, and I'm a lawyer here in India. So I have a question regarding judicial review. As you said that there is light-weighted judicial review. So what do you exactly mean by that? If you could elaborate on it. And second, it's tagged with the first question. If you are going for a more robust judicial review, then actually you will take away the shine from the commitment route which the companies may take. So if you could elaborate on light-weighted judicial review. Thank you.
I will. Thanks a lot. That's a great question. Can you just repeat the second, like your last sentence?
My last sentence is, if you say that the only drawback is that there is light-weighted judicial review, it should be more robust judicial review should be there. But in that case, you'll take away the shine from the commitment route the companies might like to take. So don't you think that's the plus point in that?
Okay, that's great. That's great. So okay, just don't get me wrong. I am not saying that judicial review will solve every problem, because every enforcement tool in the end is what you make out of it. So when it comes to commitments, as when it comes to whatever enforcement tool, it will not solve every issue if it is not incorporated in an enforcement strategy that makes some sense, that is not just parochial or practical or random, right? It will not be used in the most optimal way. So one point that I tried to make was that we will not have appropriate use of commitments unless we have pilot cases, unless the Commission tests its skills, reflexes, and thinking by pursuing infringement decisions, by litigating cases before the court. So it's also up to the Commission, right, to use commitments properly. Now, let me turn to the judicial review issue. So my points were targeting actually the Alrosa case. So in the Alrosa case, we have a conceptualization of commitments as a private contract. The court essentially says it's a compromise. It's a compromise between the enforcer and the companies. The companies voluntarily make their concessions. So we should not, as judges, scrutinize them more thoroughly. We should give to the Commission discretion, because it's a contract between these two. I doubt that this is the best way to understand commitments, because commitments have externalities. They have externalities for the market, and they have externalities for third parties. And also, if you allow these two parties, no matter who they are, right, to get too comfy with each other, then we might have problems of under-enforcement. The enforcers might feel like, okay, we did our job, let's negotiate the solution, close the case, get some concessions, and move on. So for this reason, I'm saying that it would be better to level up the standard of proof, the judicial scrutiny of commitments. So the Commission, the court, for instance, can scrutinize the way the first tier discretion is exercised. So if the commission or whatever authority, right, used commitments to deal with hardcore violations, annul the decision. Why? Because according to the principle of recital 13, this is not the proper use of the document, of the tool, excuse me. And also the court can get deeper in the analysis of the appropriateness and the necessity of the remedies adopted. So in a sense, there is margin to check further whether the remedies are inadequate. And this will push the Commission to be more strict and precise when it comes to remedies. These are ways where judicial scrutiny can improve perhaps the use of commitments. And a last note here is that increased use of commitments is not an end of itself, right? We cannot say, we should not be content that the use of one or the other instrument shows better or more enforcement. Even if we issue more infringement decisions and we impose higher fines, this is also not an indication that enforcement is more vigorous. Why? Because also lower fines might be indicative or the byproduct of higher compliance. So the purpose should be the key indicator should be how the industry performs with and without the commitments. So the authorities should, and as they do on many occasions, conduct a performance review and examine how the sector on the industry behaves after their enforcement strategy, be that with commitments or infringements, and then they can learn out of it. So for me, the key benchmark should be the real economy, how the real economy operates, and not how many, if we issue too many, like a high number of infringement decisions or commitment decisions, we should be content with ourselves. I don't know if that helps.
Yeah, thank you so much.
While we would encourage everyone to come forward and ask questions, I want to ask Stavros, and borrowing the type 1 and type 2 errors terminology from statistics or research methodology, can you help us understand with a contrast where commitments which ought to have been rejected got accepted? Commitments which ought to have been rejected got accepted by a competition authority, and versus commitments which ought to have been accepted got rejected. So type 1 and type 2 errors. Competition authorities are vulnerable to commit both the kinds of errors.
Yes.
They can accept commitments which deserve rejection, and they can reject commitments which deserve acceptance.
Yes.
With an example, can you help us understand this contrast?
That's fantastic. That's a great question. So two decisions or like two cases spring to mind. So the first case or line of cases involves certain collusive practices like the ebooks commitments. So there we had something like a hub and spoke arrangement where different publishers were organized by Apple, right, to engage in parallelism, engage in a concerted practice. We'll never know if this was a cartel because this case was decided by commitments. And we have some similar cases in the shipping industry where there are public announcements of prices and information exchanges that might correspond to might be problematic if you follow the T-Mobile case law and the Allianz Hungarian case law, where exchange of sensitive information gave rise to a cartel allegation, a restriction by object allegation. So if you ask me, these kind of cases shouldn't have been decided by a commitment decision. Now, an alternative example is the Google shopping case. So remember that this case was close to completion via commitments. So it took for the commission to reach its decision 7 years or something, because on several occasions they were negotiating commitments and they were not, the negotiations were falling apart. So someone would wonder, why is that? If this is part of a strategy to dramatically and dynamically change the market, and in the meantime you impose a fine on Google, and the fine was 2.4 billion or something, which might sound hefty, but it corresponds to 14 days of Google's operation. So is this the best use of commitments? We have a novel practice, self-preferencing, abusive leveraging, call it as you wish. We don't really know the theory of harm, or we don't really know the remedy. Is it the best way to proceed commitments? History perhaps might indicate that it's not. And a case that is successful, if you ask me, is a case that looks a little bit paradoxical, but it's not. It has to do with, I'm referring to the Motorola commitments. So the problem there was what? Was the strategic use of standardization patents. So the company that had a standardization patent was using this patent in order to secure, for instance, interim measures and block its rivals out of the market. The rivals were trying to sell something, they were using the standardization patent, they were not agreeing on the royalties, and then if they were using their phone, for instance, in that jurisdiction, then the owner of the standardization patent was applying for interim measures, and with the interim measures was able to block the rival from the whole jurisdiction. So in this case, I'm referring also to the Huawei case of the court. The court there said that the solution to this problem, this can be an abuse as long as we don't have an orchestrated negotiation. So the court there said that the court actually there stipulated the remedy. So the court said, if the owner of the standardization patent makes an offer, and then this is a reasonable offer, and then the other party has a due time to answer, to respond to this offer, and these negotiations break down, then the whole issue should be addressed to a third party that will determine the royalties, and this is the remedy to this problem of strategic use of SCPs. So this is what the court said, and in this case we have now an infringement decision issued by the commission. So the commission established an abuse in this case, and then immediately after, the same day actually, it issued a commitment decision. But the theory of harm was clear. The infringement decision did not impose a fine. So we see how here there is nothing really at stake in terms of clarity of law, and how we can economize on procedural resources. So I can assume that this was a proper use of commitments, the Samsung Motorola infringement and commitment decisions that were issued the same day.
Mr. Mohammed Azad has something to say. He was raising his hand. Mr. Azad.
Yes, sir. Thank you, sir. Thank you, Professor. It was a very interesting presentation. I'm a faculty who teach competition law here in Tamil Nadu. My doubt is, in comparison with a decision on prohibition, can you just tell me, based on your jurisdiction, whether the commitment decisions, do they establish a legal precedent? That is, I mean, can present decisions, let's say, can they act as a guidance for future assessments? Because as I could see, every commitment decision is tailor-made. It looks like a bit of an interim measure. So I wanted to know, like, can commitment decisions provide, let's say, any guidance on how to interpret the law?
Okay, that's a fantastic question. So in principle, I will tell you that commitments, since they do not include a violation of the law, they don't have a precedential value. And also, if you notice, the letter of the law says the authority considers that there are no longer grounds for action, which means, in theory, that the authority might subsequently consider that there are grounds for action. But if we look at the content of commitment decisions, we might infer different conclusions. And what do I mean by that? There are some commitment decisions, the Coca-Cola commitments, an early commitment decision that is very, very brief and sketchy. What can I infer from there? What can I learn from there? I can only learn that these exclusivity practices of Coca-Cola might be problematic. So if I am the counsel of a company that is similarly dominant, I should instruct them to abstain from this behavior. But we also have some case law on exclusivity. Now, there are some other commitment decisions. And one of them I already mentioned is the Aspen case, where if you read the decision, and I encourage you to do so, you will see a very beautiful and evidence-based analysis of what might be excessive pricing. Because the Commission was afraid that it will not be able to win an excessive pricing case, it built a robust case via commitments. So there, the comparisons of the different medicines, the different formulas are very nicely done. So it's very extensive. So from there, we can learn something, right? This is how we can navigate this terrain, and also we can see perhaps the enforcement priorities of the Commission. So if the Commission, for instance, as I was saying, with excessive pricing, uses some test cases, some commitments to deal with excessive pricing concerns, we might suspect as counsels of companies, right, that more cases of the same type will be raised, will be pursued. This is a way to address the issue. Yes, there is one more hand, I think.
Stavros, for many years, people have been looking at the way in which the Commission approaches enforcement, and that I guess I'm one of those who feel that it's often outplayed by the manoeuvring of parties with immense economic clout and the capacity to acquire the best talent in negotiation and litigation, and that I think that moving the commitment model into the digital marketplace sadly doesn't reassure me about any changes there. But my question is whether you're aware of any academic treatment of the application of game theory to the way in which the Commission and Competition Law in Europe or the UK has worked. Because I think if we had a game theory approach to this, it might be a way of putting some more intellectual rigor into the approach that the Commission tends to take.
Thank you, Alan. That's a great point. I agree with you, actually, that, and this is one of the main concerns I identify in the use of commitments, that they can lead to under-enforcement. They can lead to regulatory capture or intellectual capture. And that's why I'm advocating for a heightened standard of review, judicial review, and also for a market testing stage where the Commission will have to justify its choices, but also third parties will have a more discernible and active role. Also imagine NGOs and other civil society organizations be able to air their concerns in this kind of stage. This might be helpful. Now, when it comes to ex-ante regulation, so I hear your concerns and I share your concerns when it comes to traditional antitrust enforcement. But when it comes to ex-ante regulation, in the DMA, we have already the obligations of Articles 5, 6, and 7. So their commitments can only be a recalibration, right? Because what I was saying before, that commitments in antitrust should be used after we have a pilot case and a clear theory of harm and specific remedial solution, we already got via the DMA. So in the DMA, we have the obligation, right? So the obligation will be immediately enforceable. And then commitments can be used to make the system more workable. Now, if there is capture there, it remains to be seen. But based on the current, let's say, attitude and mindset of the Commission, perhaps, I mean, we can be optimistic. Now, about the bibliographic reference, I have to check, but I haven't found any game theoretic model. Actually, there is a paper, so I can send it to you after. There is a paper that builds a model. So two economists, if I remember well, they built a model. But this is a model, so I am not sure whether we have actual from the ground information to support the claims of the model, but I can send you the model after. And then what some of us are doing are using responsive regulation theory or smart regulation theory to identify principles or to say where the Commission did it well and under which circumstances they could avoid, for instance, particular problems associated with commitments. I don't know if that helps.
Thanks very much for that.
Thank you everybody for asking questions.